But anyway, we're back with another video, and basically, in this video, I basically want to go through the default order that Heather Williams received because R. Kelly didn't respond and he didn't show up in court. And here it is. I'm not going to get too deep into this. And it basically says that an order for default is hereby entered against the defendant, Robert Sylvester Kelly. And then it says this matter is on prove up on damages, right, on 5/8/19. And then, yeah, that's it. That's the gist of it, right? So it looks like they're going to be back in court next month to basically look at the damages, right? So they can award the defendant with damages, but not too fast because I think R. Kelly has filed an appearance here, right? So this is R. Kelly's filing of an appearance, and he filed a general appearance, and the counsel of record is Abdallah Law, and here is his response, right? So basically, now comes the defendant Robert Sylvester Kelly. Hereafter, the defendant by and through his attorneys Abdullah Law and Ray Shalabi Ltd. I'm sorry if I didn't pronounce that not right. Let me try it again. Raid Shalabi, and moves this honorable court to set aside technical default against the defendant pursuant to Chapter 735 ILCS Section 52-1301. Right? So I think if you've been paying attention to my videos, you can go and watch the other set of videos. I think it's called Four Possible Arguments that R. Kelly can make to vacate this judgment. And I mentioned that he would basically file a 1301, right? So he filed 1301E in support of his motion. He states the following: Introduction. This matter is cause of action filed by the plaintiff, Harry Williams, hereafter. Plaintiff for sexual abuse. The plaintiff said cause of action on around February 21st, 2019. The defendant was allegedly served while in Cook County Department of Corrections. This matter was defaulted on the first management date of April 24th, 2019. Right? Facts. On February 21st, plaintiff filed a cause of action for sexual abuse against the defendant. Prior to the defendant being served, the plaintiff filed a motion for alternative service. In said plaintiff's motion, counsel asked to serve the defendant's counsel on the defendant's criminal case, Steve Greenberg. Plaintiff counsel has known Mr. Greenberg for decades, right? Despite knowing Mr. Greenberg, the plaintiff's counsel never bothered to reach out to Mr. Greenberg and inform him of said cause of action. Plaintiff's counsel did not need the court's permission to inform Mr. Greenberg of cause of action. It would have been of interest to justice to inform Mr. Greenberg instead of having the defendant default on very first case management date, right? So to me, it just basically looks like they tried to serve Mr. Greenberg, who is R. Kelly's lawyer, and I'm not sure if that went through. But essentially, what this is saying is that they never, called him, sent him an email, called him on the street and said, "Hey, we got your, we're trying to sue your client. Why don't you tell your client that he's being sued?" Right? So it looks like none of this ever happened. Let's read on. In said filing, plaintiff's counsel creates an impression that the defendant could not be served at his home because of building security. This is false because security from Trump Tires will actually walk law enforcement to a resident's dwelling and allow for service to be completed. This same procedure was utilized in Mrs. Kelly's child support case as recently as February 2019. The affidavit of service states that the defendant was served on March 8, 2019. This would mean the defendant was served while he was in custody of the Cook County Department of Correction. The defendant does not recall being served. The defendant suffers from a learning disability and adversely affects his ability to read. In essence, he cannot. Equally relevant, the lawsuit was not yet discovered in the criminal case. As soon as several news outlets reported the default judgment in this case, Mr. Greenberg informed the defendant of the default judgment. The defendant immediately retained counsel to represent him in the above caption. So, argument: the court, in its discretion, the court may, in its discretion, vacate and set aside a default prior to final judgment being entered on a motion filed within 30 days of the default judgment. Uh, Chapter 735, Illinois Compiled Statute, Section 5-2-1301E. A trial court's refusal to vacate a default judgment may be reversed because of a denial of substantial justice or because of abuse of discretion. Factors to consider in determining whether substantial justice has been served includes the severity of the penalty to the defendant as a result of the judgment and the attendant hardship on the plaintiffs if the plaintiffs are required to proceed to trial on the merits. The question of whether a court should set aside a default should be so resolved as to do substantial justice between the parties with the idea in mind of carrying out, insofar as much it is possible, the determination of the matters upon the merits. What is just and proper must be determined by the facts of each case. And this is case law Vinzor v. Carmen Pisa Court. The severity of the penalty against the defendants here is great. The plaintiff is claiming damages in excess of $50,000. Potentially in the millions could be awarded. The interest of justice requires that the default order be vacated by this honorable court. The defendant has a meritorious defense and would not be able to defend himself against such egregious allegations if the honorable court does not vacate the default judgment. Conclusion: the defendant has acted diligently and the defendant has good cause as to why he did not respond to the plaintiff's complaint. Substantial justice will be achieved if the default judgment in this matter is vacated. Wherefore, defendant Robert Sylvester Kelly prays that this honorable court enter an order to vacate the default judgment that was entered in April 24th, 2019, and for such other relief this honorable court deems just and proper. So to me, just to finish up this section of the video, it's, to me, it looks like they're saying that they knew his criminal defense attorney, but they didn't make an effort to, call or contact him so that R. Kelly could be aware that he had this lawsuit. Instead, they chose to serve him in prison, right, when he was being held for the child support claim, which I originally said in the other videos. I thought he was being held for the sexual abuse claim. That's not true. According to this, he was held for the child support claim. Nevertheless, the claim of sexual abuse and the claim of child support was basically his chief concern. Probably more the sexual abuse claim was his chief concern, right? So in my untrained opinion, again, I'm not a lawyer. I'm definitely not a judge, and I'm not licensed to practice law. But in my opinion, it really wouldn't be fair if they didn't vacate this judgment because the guy was in prison. He was worried about his sexual abuse claim, in which he's pretty much going to lose his life. Not lose his life, but be locked up for the rest of his life if he loses that case. And then on top of that, he had a child support case, which he was actually being locked up for. So I'm actually surprised that they didn't just say he was under duress, right? Because that would have been a legitimate claim. It looks like they're just saying that, hey, look, substantial justice cannot be served if you don't vacate this judgment because he really didn't have a fair chance, and basically it's going to be a violation of probably due process of law, right? So that's it with this. So I'm going to continue on to the next video where I basically run my mouth and talk about things I don't know about and talk about possible strategies for R. Kelly in this case. So I'll see you in the next video.